Welcome to this video, and today's topic is how do I draft an urgent application to the High Court to relocate with my minor child. In this specific example, we chose the Commonwealth of Australia, the place where the mother, Kate Wellington, wants to relocate to with her two minor children, Nina Wellington and Sandy Wellington. The father in this matter is Tom Wellington, and he is obviously the respondent in this matter. Firstly, this is an urgent application, and for that reason, Kate Wellington wants to have this matter resolved as soon as possible. And her strategy for that is she wants the office of the family advocate to be appointed as soon as possible. And once they have filed their report and made recommendations, the matter should be heard on the semi-urgent roll on the Western Cape High Court's roll. As I go along and go through the application, you will learn some things. And if you are intending to relocate, you would pick up some things that would be applicable to your specific case, and some might not be applicable to your case. However, at the end of the day, the principles are the same. Your application must be in the child's best interest. So let's get started. The document to initiate legal proceedings is called a notice of motion. So these are application proceedings. The notice of motion would start off with the parties' details, Kate and Tom, a date for the urgent hearing. Point 1 here would be condoning non-compliance because a normal High Court application takes some time and there are certain rules, and you want to be heard urgently. And as we'll see later on, there is a rule nisi. But what you're asking the court now is for the family advocate's office to do an investigation into the well-being and best interests of the minor children, Nina and Sandy, and to file this report within 10 days of the return date. Part B, the issuing of a rule nisi, whereby on the semi-urgent roll, on a semi-urgent date on the Western Cape High Court's roll, the matter would be finalized. And usually a semi-urgent date is much sooner than a normal date, but a bit later than an urgent date. And this is what you're asking for. 3.1. The parties would remain co-holders of parental responsibilities and rights. Point 2, and we made it in red. The respondent's consent is not required for the application and or renewal for the minor children's passports. That is something many people do not deal with or include. And his consent is not required for the minor children to relocate to Australia. His consent is not required for return visits. And should anything arise while the minor children are in Australia, where the father's consent is usually required because he is a co-guardian, under those circumstances, his consent would not be required. And an example is given: schooling, renewal of passports, overseas traveling, medical treatment, and so on. We'll deal with the issue concerning the father's contact. So they will reside primarily with the mother, and the father can have telephonic or video contact during those times. And he is entitled to have contact with the minor children in Australia, and many times we include that the minor children should visit South Africa to have contact with him. It all depends upon the circumstances of the matter. And in this specific case, the family advocate would have to investigate this matter. They would have to consult with the parents and with the minor children and make recommendations to the court as to what parenting plan or parenting arrangement or contact arrangement would be best for the minor children. They would obviously look into the issue concerning sole guardianship. Should the father's consent regarding traveling, medical, and so on be dispensed with, or should it be included or not? There's a timetable. The lawyers for the mother in this case is ABC attorneys. The father can file documents on them. However, within 5 calendar days of receipt of this application, he must inform them whether or not he's opposing this application. And by 1400 on Friday, the 20th of February 2026, he must file his answering affidavit. You will see later on, we provide you with a draft founding affidavit, meaning the affidavit of Kate Wellington. The father would have to file a response or an answer to that. And after the father has done so, Kate Wellington may file a reply to that. Here it says, take notice further that the affidavit of Kate Wellington and supporting and or confirmatory affidavits attached hereto will be used in support of this application. This application is dated today. When watching this video, it will obviously be a different date. And then the attorney for ABC attorney signs it. If you are making this application yourself, underrepresented without an attorney or an advocate, you will stipulate here in person, and it gets sent to the High Court, the family advocate, and to Tom Wellington. Tom Wellington is the father. So in short, that's the notice of motion, the document that starts application proceedings, whereby you explain to the other side what you want and you attach an affidavit in support of that. This specific application is not as a summons, action proceedings, where the parties will come to court and testify. Here you testify on your affidavit. Now, what does your affidavit stipulate? You start off as follows. Kate Wellington, she's an applicant. You deal with where she works, where she resides, any other information that's applicable. She may say that she received a job offer overseas and she lives in between countries. That might be relevant. Regarding Tom Wellington, where he works, where he resides, and so on, you might stipulate that he's married, he might have children with someone else, whatever is applicable. Or you might stipulate that he might live in Cape Town and in another province, whatever is relevant to him. Now you introduce the minor children, Nina and Sandy. You say which court has jurisdiction, in this case the Cape High Court, the Western Cape High Court. You give an introduction to the judge because the judge will be reading this document, what it entails. There's a part A, as you've seen, to instruct the Office of the Family Advocate, a part B, which is the Grundisi, stipulating exactly what you want from the court. And now you can be creative as long as you provide the court with all the relevant information. Current care and contact arrangements, formally requesting consent from the father for the relocation. Also, reasons for the relocation, important. Here we give some examples: better employment opportunities, better quality of life in Australia, better cost of living, safety and security, better and free medical insurance, free schooling and subsidized university courses, and anything else that's relevant. Views of the minor children regarding the relocation depends upon their ages, can be very relevant. If the minor children wants to relocate, obviously it's something that you'd want to mention. If they do not want to relocate, mention it anyway, but explain why it will be in their best interest. The Office of the Family Advocate would have to look into that. Some relevant background, for example, when you and the father met, were you married, when you separated, when you divorced, certain challenges you had, whatever is relevant. About Nina, she goes to school, grade this, she enjoys soccer, tennis, swimming. About Sandy, the same day. If they have any specific medical conditions, please mention it. Timelines and logistics to relocate to Australia. Very important because that plays a role in urgency. So in this specific scenario, it's not that urgent because she is setting this matter down on a semi-urgent role, which is in a few months' time. However, there can be a scenario where it becomes very urgent. However, if there is no job offer and she ultimately intends to relocate, it is obviously not urgent, and the structure of a notice of motion will be a bit different, and the timelines will be different. Schooling arrangements in Australia, very important. Before the relocation takes place, the judge or the court wants to be convinced that the minor children will have a school to go to. I also sometimes include medical amenities and also things like parks, swimming pools, soccer fields, sporting fields, and so on, all to support your application for the relocation. That should the minor children leave South Africa, they will be cared for well overseas and have all the amenities that will benefit them in the long run. Contact by the respondent after the relocation. Very important provision. You need to deal with this. How will the father in this scenario continue having a relationship with the children after the relocation? That is very important. Before I conclude this, any other relevant information that might be applicable under these circumstances? The constitutional rights, nice to mention it in the documentation. It reminds the court about the constitution, freedom of movement, freedom to leave the republic, and so on. A right to a passport, children's best interest, or the constitution and the children's access. The urgency of the matter, section 64B of the Children's Act says the following: in any matter concerning a child, a delay in any action or decision to be taken must be avoided as far as possible. And you argue your case further. Final relief sought, you mention to the court what you want in part B, just to summarize things. And then you deal a bit with urgency, why it is urgent. It is obviously urgent because the mother got a job offer, and the job offer will have to be accepted as soon as possible. And furthermore, the children would have to be enrolled into schools as soon as possible in Australia. And then you conclude and you say, as upper guardian of all minor children in its jurisdiction, I respectfully implore this honourable court to protect the minor children's interests and override the rights of the respondent as prayed. I am indebted to this honourable court for its valuable time. And it's signed by Kate Wellington. She'll print out this document, take it to the police station. If there are any annexures or attachments to it, for example, maybe a job offer, maybe the birth certificates, the ID documents of the parties could be relevant, flight tickets, schooling information about the school that side, letters of acceptance from the school, maybe the school reports of the children locally and so on, a current pay slip. If she is struggling to live in South Africa, those relevant information as well. And there you have it. You complete this process, you issue the application in the Western Cape High Court, and as in many other courts in South Africa, they are online. You issue it online, you serve it on the respondent, and then he will get an opportunity to respond to what you have said. And then the court will listen to both sides of the story, and the court will have to now make a decision what is in the minor children's best interest. And hopefully, if the court is on your side and the court decides that it would be in the minor child's best interest or children's best interest to relocate to the Commonwealth of Australia, the court would make such an order. And at the same time, the court would include therein the relevant provisions, for example, that you solely make decisions regarding guardianship issues in Australia, and that the father in this example would have proper contact with the minor children thereafter. Otherwise, best of luck and thank you for watching this video.